Ready? 3, 2, 1, start. It is further made clear in the impugned notice that in case election of the President and Vice President is not made in this meeting as per rules, then the elected council shall be deemed as dissolved without any notice or order. Stop. Consideredly, none of the ward members or nominated members have been impleaded as party respondents in the present petition, who are to elect the President and Vice President from amongst themselves. Thus, they are necessary and proper party while challenging the impugned election notice. Stop. The law is well settled that in the absence of a necessary party, the writ petition is incompetent and necessary party is one without whom no order can be made effectively, and proper party is one in whose absence an effective order can be made, but his presence is necessary for complete and final adjudication of the matter, and reference in this regard can be made to 2002 1 SCC 33 Ghulam Qadir versus Special Tribunal and others. Stop. Para 43 of the same reads as under. Para. This court has in Udit Naren Singh Malpaharia versus Additional Member Board of Revenue held that in the absence of a necessary party, the writ petition itself is incompetent. Stop. It further held that a necessary party is one without whom no order can be made effectively, and a proper party is one in whose absence an effective order can be made, but whose presence is necessary for complete and final decision on the question involved in the proceedings. Stop. On the basis of various judicial pronouncements, the court concluded that in a writ of certiorari, not only the tribunal or authority whose order is sought to be quashed, but also parties in whose favor the said order is issued are necessary parties. Stop. Undisputedly, present petition has been filed by the petitioner in his individual capacity, but he is neither proved to be a voter nor claiming a prospective candidate for the post of President or Vice President. Thus, in the opinion of this court, petitioner cannot be termed as an aggrieved person who is likely to suffer any injustice, much less substantial injustice. Stop. It is equally well settled legal proposition that for invoking the jurisdiction under Article 226 of the Constitution for issuance of a writ of certiorari, it is prerequisite to prove the legal injury suffered by a party approaching the court, but petitioner has miserably failed to substantiate the same. Stop. Thus, the petitioner is having no cause to file the present writ petition under Article 226 to challenge the impugned election notice, and lacks standing for the discretionary relief based on extraordinary jurisdiction of this court. Stop. In view of the facts and circumstances discussed herein above, petitioner has miserably failed to show that he is an aggrieved person for the relief claimed in the present writ petition. Stop. Consequently, this court has no option except to dismiss the same only on this ground. Stop. It is clarified that this court has not examined the legality and validity of the impugned election notice dated 1/6/2020 on the touchstone of sections 9 and 18A of the Act of 1973. Over.